All right, this is Jason Heckman with Integrity Financial Group, here to interview Joe Boyles, second-generation estate planning attorney, on some of the common misconceptions when it comes to estate planning. So let's take it away. All right, Joe. So we've done several events together, and we always seem to get the exact same questions in every one. A lot of people assume that they have to be very wealthy to have a trust, that it's all about assets over and above, the rules that you can place in there to save families. I think it's a relationship saver. But a lot of people don't understand that the difference between a will and a trust. So what would you say the main purposes for each of those items would be?
Sure. Well, a will is your absolute necessity. A will is what you need to have no matter what, even if you do need a trust. A will is a document that lays out your wishes, what you want done with your property when you die. It must go through a court in order to take effect. A judge has to look it over, make sure that it's valid. The beneficiaries all have to be noticed. The executor has to be appointed. It takes a while, but it's a necessary process in order to execute the desires that you put in your will. A trust is very much what we'd call an extrajudicial document.
Right.
It allows you to handle all this stuff without the necessity of going in front of a judge, without anybody looking over your shoulder all the time. There are checks and balances if somebody does anything wrong, but it removes a lot of the bureaucracy from things, speeds up the process, allows your heirs and the people that you've put in charge of your assets to hit the ground running after you died.
Right. And a lot of the things that I've seen out there running appointments for 19 years and meeting with different people, there's several people out there that end up with a trust that they've spent a lot, sometimes a considerable amount of money on, and it's not funded. So what would be the importance of making sure that you have the follow through? Because I know that you and your team are very good at follow through. And with both of us working together, the left hand knows what the right hand's doing, so we make sure it's funded and it's funded properly. What happens if half of the assets are not inside of the trust?
Anything that's not inside of the trust is going to have to go through probate. It's going to have to go per the will. So what we do is that just in case there's anything that hasn't been put in the trust properly, even if you have a trust, you should have a will, because it's what we call a pour-over will. It dumps anything that's not already in the trust into the trust at your death.
Right.
A trust, the best analogy that I give people is a trust is like a box that you set up. It's a box that you're going to put your assets in, and then the document that you've created is the rules of what you're supposed to do, the instructions for what you're supposed to do with what's in that box.
Handling it from the grave, essentially.
Right. And anything that's not in the box isn't going to be managed by those rules. So if you have an insurance policy that's payable to someone, it's not going to go through the trust. If there are any rules about how it can be used or whatever, they're not going to apply to anything that doesn't pass through and is not governed by that trust document.
Right. And then essentially you used a lot of money that when you purchased the trust, and then now it's almost useless.
Yeah.
Yeah.
If it's not, it's like anything. If it's not properly executed, if it's not properly funded, it's a piece of paper.
Right.
And
Right.
there are plenty of people that come in with very expensive notebooks full of paper that haven't properly been funded or managed.
Right. So what would you consider a proper amount of time to reevaluate your estate plan? Let's say if you've done it 5+ years ago, how often should you make sure you check that it's still legal and everything's still proper?
Sure. We try to set up trusts so that they're set it and forget it, so that they're future proof, so to speak. That being said, it's important to reevaluate if you move to a new state or new jurisdiction, if the type of property you own changes, if you own or purchase real estate in multiple jurisdictions, multiple states, if your beneficiaries change. So if you have additional children, something happens to one of your children, a relationship with one of your beneficiaries either sours or improves.
Right.
Major changes in assets and beneficiaries, and also the people that you've chosen to put in charge.
Right. Right. So essentially, if you were to build a estate plan and you do it properly, like with your agency, 10 years ago, as long as there hasn't been any major changes, then you really shouldn't have to update it.
Sure. I mean, I have some people come in after someone has passed away and bring in documents, and I look them over, and they're they could be from 1972, and they're perfectly valid, and they work exactly as they intended them to work. Now, I also have people come in with documents that they had prepared last year that either weren't done properly, or that there have been changes significant enough in their life that they need to be changed,
Right.
amended.
So, on our events, I've heard a lot of people that go online and do their own estate planning with these certain websites where you can actually just build them out yourself. And I've heard through you and Aubrey that it's a very bad idea to try to do that on your own.
I can usually tell pretty quickly if a document has been produced by a non-lawyer. At the worst case scenario is that it's not properly, well, maybe that's not the worst case scenario. One of the bad scenarios would be that it's not properly executed. There are very specific rules on how witnesses must sign, how it needs to be notarized, and things like that. And if those aren't done properly, then it's not a will at all, it's just a piece of paper. Now, there are also problems where if if the document wasn't drafted by someone who was skilled, then it may not do what you intend to do, or it may do what you intend to do, but also have unintended consequences as well. And those can range from people being accidentally cut out of the will, people inheriting things that you never wanted them to inherit, um, and uh, and just gaps so big you could drive a truck through them.
Right. And it seems like it's such an important part of your financial plan that you really need to seek proper counsel. Somebody with that has passed the bar, they have the license, they have the know-how of the legalities that are behind it.
Sure. And even I will say that even if someone's passed the bar, they may or may not be properly skilled to handle certain types of estates.
I've actually heard of that. I've heard that there's attorneys out there that kind of dabble in everything. So somebody comes to them in their office, and they're typically an accident or a business attorney, and somebody says, "Hey, can you build an estate plan?" And so they dabble in that copy
Right.
and paste sort
We
of
call
thing.
them door lawyers. Anything that comes in the door is the type of law they handle.
Right. Right. Yeah. Anything to make some money.
Right.
So whenever we built the agency years ago, we really wanted to have that partnership of everything under one roof, because many times I've seen it where they weren't funded and they weren't funded properly, or they got sold a trust when they actually didn't even need a trust.
Sure.
A will would have sufficed, but they were obviously sold a trust because it's the more expensive thing to charge for. What I like about our whole group is every single one of us like to do what's best for the client.
Sure. People come in, and sometimes people come in and say, I need a trust. And after we sit down and talk, it turns out that what they actually need is a far more simple plan that's going to cost less, but actually be more effective for their needs and more suitable for what they're trying to accomplish.
Right, right. And, it's just unfortunate. There's a lot of things that happen out there. When you meet somebody, there's two things that's going to happen. You're going to do something for you, or they're going to do something to you. So having everything under one roof and everybody working together where the left hand knows what the right hand's doing, we make sure that everything is put in place properly. And you get the right plan for the right reasons,
Right. Yeah.
per se.
I'm not a salesman. I'm not trying to, put you in a new trust to drive off the lot today. But we're often called attorneys and counselors. I try to work with people through whatever they need to figure out to get what they want on paper to protect their family and to protect their legacy.
Right. I always look at trusts as almost like a relationship saver over and above an asset protector because it's very difficult if you're sitting on this side of the table with your attorney and your sister or brother is sitting on the other side of the table with their attorney. It makes Thanksgiving a lot more awkward if anybody actually
Oh, yeah.
shows up. So, and the mother and the grandmother at the top of the family is typically the glue that holds the family together. And they're the ones that put the Thanksgivings together, they put the Christmases together.
Right.
So, one of the last things that they want to happen after their passing is a bunch of family members start fighting over their belongings. So, it just seems very simple to me that you just put a trust in place. It doesn't cost as much as you would think it would. And everything's satisfied and it keeps people from going to court with one another.
Oh yeah, if they're not done properly, it can be a mess. And there's so many different variables that can pop up that you really need someone with a real holistic understanding of the family relationships, of blended families have special, very special needs that they to make sure that the surviving spouse is taken care of, and the children of the person who's died are taken care of. That everybody's needs are met, and that there can be a lot of unintended consequences if you're not aware of those relationships and things like that beforehand.
Right. The other thing that I hear you and Aubrey mention a lot is there's a couple of documents that everybody needs. We have a lot of documents with estate planning when it comes to after your death, but what about the documents that you need while you're still alive?
Well, power of attorney and healthcare documents are crucial for really anybody. I recommend them to anybody over the age of 18 who has somebody that they can trust to help them manage things. A power of attorney gives another person or people the ability to transact business, property things, contracts. Depending, they can be very narrow or very broad in the powers that are granted.
Right.
But it allows somebody to transact business for you. That can be important if you are in a car accident and you're in the hospital and unable to, get to the bank or pay your bills or whatever. It's also useful if you're traveling and you're in Europe and you need somebody to sign some documents for you at home. The healthcare document is also crucial because without it, there is no ability, once someone is over the age of 18, for people to make medical decisions for them. That includes parents of college-age kids. That as soon as
Which
they
is a
turn
big
18,
deal right now.
exactly, as soon as they turn 18, your ability to make choices for them if they are not capable while they're in the hospital or receiving any kind of medical treatment, you're forbidden from doing that. And so appointing a healthcare surrogate is really, really crucial, and it helps you during your lifetime.
Right. Yeah, those are the documents that we really appreciate while we're still living.
Right.
And I hear a lot of times that the people think that if their wife, let's say you and your wife were to get into an accident and your wife is unconscious and she's racking up medical bills and you need access to her stock portfolios. We don't have the ability to give the husband access to those accounts if his name is not on it without those proper documents in place.
Right.
And
Manage an IRA or any kind of account that can't be joint.
yeah, correct.
My wife's a teacher, and so she's typically unable to leave her school during the workday, and so I use a power of attorney for her to manage financial stuff, sign tax returns, things like that I would not be able to do if I didn't have that power of attorney.
Even something as simple as updating a tag on your car.
Yeah, exactly.
Yeah. So, what are the things that you can think of that are very important for people to know that you've ran into with clients?
Doing, as we've discussed before, doing your own documents can be can be very problematic. Not just wills and powers of attorney and things like that, but the most common documents that we see that people draft themselves are deeds.
Really?
People draft their own deeds and record them all the time, and oftentimes they don't accomplish what they're intending. They either don't witness it properly, or they mess up the words, the wording of it. They put the wrong property description or an incomplete property description. And all of these things lead to the property not belonging to who they think it belongs to.
Something simple that could cause a ripple effect.
Oh yeah, it can. And if you don't discover it for, 5, 10 years, the people that could fix it may not even be alive anymore. And so that
That's
involves
true.
litigation and all sorts of other problems.
Right. So one of the things that you mention a lot is if you don't have these sort of documents in place, there's something that you mentioned that cost $8,000 to just start off.
Yes. So if you don't have a power of attorney or a healthcare surrogate named, and you are either, incapacitated after an auto accident or something like that, or as you get older, you develop dementia or have a brain injury or anything where you're not able to communicate your wishes, then if you don't have those documents, the only way that someone who cares for you can make those choices is if they have what's called a guardianship. And that is a proceeding where you go to the court, you tell the court, we believe this person is no longer competent of exercising their civil rights, basically. Their right to vote, their right to make decisions for themselves, their right to manage their property, the right to choose where they live and who they interact with. And because they can't exercise those rights anymore, someone needs to step in and exercise those rights for them. And it's not the rights that you've chosen in a power of attorney. It's whatever is determined by a panel of 3 medical experts who visit with you and make those decisions and relay that to the judge. It's a very expensive, it's a long process, and worst of all, it's very, very stressful for the people who have to go through it.
Right.
Because they are being told in court that they are incompetent. You are being told that you're incompetent. And that's just a stressful time for really everyone involved.
I'm sure it could be.
And-
And all of that is because of the proper documents weren't put in place in the beginning when somebody was competent enough to do it.
For a few $100s, all of that can be avoided.
Wow. Very inexpensive. Right. So let's think of some other things that we run into that could help the people out there when it comes to the estate planning side.
There's one document that sometimes we use that's really interesting in Florida. Only a few jurisdictions allow this. It's called a ladybird deed or an enhanced life estate deed.
Right.
We sometimes call it a poor man's trust. It allows you to create a transfer on death beneficiary for your property, for your real estate property, instead of using a trust. So for families that have maybe they have one child that they want to leave everything to, there's not going to be kind of the disputes of ownership and whatever that you may have with multiple children. It allows you to name that child as the person who will receive the property at your death, or in the case of a married couple, the second spouse to die. And the great thing about this ladybird deed is that it's reversible. So if you decide you want to sell your property, if you decide that you want to change who that beneficiary is, or the beneficiary dies, or whatever, you can make those changes. You can give it back to yourself 100%. You can change the beneficiary. You can sell the property. You can remortgage it. You've got complete authority over it until your death.
And it's still something that you want to seek professional
Oh, definitely.
assistance with.
Definitely.
And because I've always heard that there's only two people that can sign off on the transfer of property. It's a judge or a trustee, which the Lady Bird deed will help avoid that.
Right.
Right.
And because the other nice thing is that because it's the actual transfer doesn't happen, because you're able to change it whenever you wish, the transfer doesn't happen until your death, which means that for tax purposes, your beneficiaries get a step up in basis. It erases all of the capital gains potentially on that property,
Which is great.
which is really
Yeah.
good, and which you do not get if you give someone your property during your lifetime.
That's great information. That's probably very helpful.
So.
So while we're rolling, what else do you think of that we could put out there for the people? It's a lot of misconceptions.
Yeah.
One of the things that I see people that hold people back is not knowing who they could count on as a trustee, or not knowing the rules that they want to associate inside of a trust if they're going to build a trust. So it kind of stops them from taking that next step.
Yeah.
I'm always under the assumption that you should take the step, and then you and your team will help them walk them through each and every
Sure.
piece of it.
Jump out of the airplane and work on your parachute on the way down.
That's right. Entrepreneurship.
A lot of people suffer from analysis paralysis, and they think that because they don't, even when they're filling out, say, an intake form for my law firm, that they think that if they don't have all the information, if they don't have all their decisions made, they can't come in. And what I've found is that oftentimes the process of meeting and talking through it and going over some of the options and things like that really helps them to develop what they want to do, who they want their beneficiaries to be, how they want their estate managed.
Right.
And that's another thing that I think, even in a situation where if you had an online document, those types of questionnaires don't delve into the truly important things about family relationships. Does one of your beneficiaries have a drug problem? Do you have a beneficiary who might need be protected from the money, protect themselves from their own
Right.
finances? Children that may, or beneficiaries rather, that may have special needs that may qualify for government benefits, structuring things so that they have the access and the use of these funds without it disqualifying their benefits that are so important. There's a lot that can be done if you come in and we work through the issues.
Right. A lot of clients don't understand that how quickly you could turn a blessing into a burden for your beneficiaries. If it's not properly taken care of while you're alive and cognitive enough to do it, you could, without a shadow of a doubt, turn a burden into a blessing. I mean, a
Sure.
blessing into a burden.
Sure.
Thank you for watching. We'll have these podcasts going up at least once a month, and thank you very much. See you next time.